How many of you have seen those old-fashioned cartoons where the cartoon character walks through a landmine and basically steps on every landmine and then gets to the end of it and steps on a rake and hidden himself right square in the forehead? Well, metaphorically, that is what a judge has done in the United States District Court for the Northern District of Illinois when it comes to analyzing so-called assault weapon bans and large capacity magazine bans. Basically, when it comes to their legal analysis, there's so many mistakes in this major opinion, I don't even know where to begin or end. So I'm going to try my best. But the bottom line is, it's a mess. Stay tuned. I'll walk you through it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. All right, so we have breaking news here, folks. We have a decision in the United States District Court for the Northern District of Illinois in a case called Bevis versus City of Naperville, Illinois. Judge Virginia Kendall in the Northern District of Illinois has refused to enter an injunction in favor of the Second Amendment plaintiffs who had brought a challenge, to make a long story short, to the bans on the sale of and the possession of large capacity magazines, which, as you know, is a political propaganda term for standard capacity magazines that hold more than 10 rounds, as well as so-called assault weapons, which, as you know, is, again, another propaganda term for semi-automatic rifles. Now, this decision by Judge Kendall is horrific in terms of it's entirely incompetent. It applies the wrong standards. It misanalyzes cases. And frankly, if I had an attorney that worked for me, produce a work product like this, I would have to seriously consider firing them. To begin with, and before we walk you through the analysis here, this judge essentially applied an old-fashioned, unconstitutional, interest-balancing test, which is totally not allowed under Naperville versus Bruin and Heller. And she did so under the guise of history. History that is way too late, totally irrelevant to bans on arms. She also applied the entirely wrong legal standard, which, as you know, when you're dealing with an arms ban case, not a regulation, not a restriction, when you're dealing with an arms ban case, whether it be a magazine, which is a form of arm, or a semi-automatic rifle or semi-automatic handgun, which is a form of arm, you apply the in common use test. Not applied here properly. She also misanalyzes William Blackstone, the English commentator, which is pretty hard to do. Well, she does mention he, of course, has a notion of dangerous or unusual, but that's not the American standard as adopted by the Supreme Court, which is actually the standard of dangerous and unusual. She got the or versus the and wrong. Beyond that, she also misunderstands the notion of the in common use test as applied to dangerous and unusual. And last but not least, what's most interesting is she tries to sort of draw this argument or make this argument that semi-automatic rifles are particularly dangerous, adopting a whole slew of propaganda allegations and pseudo-facts, as I see it, ginned up by gun controllers about things like rates of fire and kinds of wounds that you can get if you get shot with a .223 round or a 5.56 round and so on and so on. But the bottom line is that this decision is poorly reasoned for a whole host of reasons. Let me walk you through it. So to begin with, you know you're on the wrong path when the opening lines to this decision by Judge Kendall in the Bevis case starts off with after several mass shootings, and then this opening also on the first page, she talks about mass shootings have become common in America. Okay, none of this is true, but again, the point is it doesn't matter because the Supreme Court has already said repeatedly, going all the way back to Heller, that talking about the balancing of public policy considerations of legislation when it comes to firearms is totally irrelevant when you're applying the Second Amendment's right to keep and bear arms. You are an attorney. You are a judge. You apply the law. You're not a policymaker. This is not my opinion. This is what the United States Supreme Court has said in Heller when they said that interest balancing tests are not permitted by judges in the Second Amendment context because the Founding Fathers already did the interest balancing test between having guns or not having guns when they adopted the Second Amendment. Game over, full stop. That is the balancing test that was already adopted, and Bruen reiterated this fact when it rejected all those two-step interest balancing tests that lower courts in parts of America had been embracing for the 10 years after Heller and before Bruen. Nevertheless, on page 1 alone, Judge Kendall starts talking about mass shootings as if she's trying to stand up and give some speech to a city council, as opposed to apply the Constitution to the facts in the case at hand. That's the first thing. Now, the second thing I want to note is on page 2, she uses the words semi-automatic rifle 3 times. She does that because, of course, she is quoting the relevant regulation and statute. A semi-automatic rifle that has a magazine, a semi-automatic rifle that has a fixed magazine, a semi-automatic rifle into a machine gun. The point is, she's talking about semi-automatic rifles. Bing, 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 bing. Guess what? When you're talking about semi-automatic rifles, and then you begin what Judge Kendall later on does, is she starts to refer to these as really military-style weapons, and they're like machine guns. But you know what, folks? Guess what she doesn't cite? And you, watching this channel, would know better than Judge Kendall. What does she fail to cite? She fails to cite anywhere in her 35-some-odd page decision here the United States Supreme Court case of Staples versus the United States. In Staples, I believe it was decided in 1994 or so, the United States Supreme Court specifically talked about how semi-automatic rifles were routinely owned by ordinary Americans all the time, and that was in stark contrast to machine guns. So here you have a federal judge that is trying to argue that semi-automatic rifles are indeed analogous to machine guns, are somehow assault weapons, are particularly dangerous, and yet fails to cite the most basic Supreme Court precedent for the notion that semi-automatic rifles are different than machine guns. That would be the Staples case. Again, it's not my opinion. This is what the United States Supreme Court said. And as you know, under Article 3 of the United States Constitution, the Supreme Court is the Supreme Court, and judges like Judge Kendall are known as the inferior courts. Not my phrase. That's in the Constitution itself. District court judges, inferior courts. That's just the way the system works. And it appears that Judge Kendall, in this case of Bevis versus City of Naperville, simply has failed to acknowledge the Supreme Court precedents for one reason or another. I'm guessing she doesn't like guns and likes gun control. That seems kind of obvious to me if you read this opinion, because it reads in many respects more like a propaganda tool by the anti-gunners. But let me carry on and let's continue to analyze how this works. In her first footnote, she says she's going to refer to semi-automatic weapons as assault weapons. That's right. She actually says that. Here's what she says, that she's going to give these terms the terms that are widely accepted in modern parlance. No one calls semi-automatic rifles anything but semi-automatic rifles unless you're a gun controller or an anti-gunner. And then them, of course, are your handmaidens in the media who are going to just reiterate this because they don't know anything about guns because they live in New York City and aren't allowed to touch guns. So here you have a federal judge is conveniently going to call these weapons assault weapons without acknowledging that the Supreme Court has specifically said that semi-automatic rifles are ordinary rifles in the Staples case, and of course basically reiterated the same notion in Heller and in Caetano talking about semi-automatic pistols. Again, she conveniently glosses over the fact that semi-automatic weapons are not machine guns because she basically wants to conflate the two just like any other gun controller would. Now let me carry on. So the next major mistake that Judge Kendall makes in this case is she yet again misinterprets what the Heller case stood for. This is what she writes. The Supreme Court first recognized that the Second Amendment enshrines an individual right to keep and bear arms for the purpose of self-defense in Heller. No. The Heller case said that we have a right to keep and bear arms for all lawful purposes such as, which means, for example, self-defense. Because if you read the dissent in Heller, which apparently Judge Kendall or her law clerks failed to do, it talks all about how the majority opinion is contemplating things like hunting, self-defense, recreational uses, and all other purposes that are lawful, as did Caetano, which talked about having semi-automatic handguns for all lawful purposes as well. Yet again, she immediately talks about it has to be for self-defense. That is simply not the case. The next mistake that Judge Kendall makes is on page 13 of her opinion. Then she goes on and she says that the Bruin case set forth a, quote, new standards for applying the Second Amendment. No. How many times do you have to go over this? Heller set forth the standard of text, history, and tradition, and specifically said that interest balancing tests are totally unacceptable and not permitted by judges in the context of the Second Amendment. Certain judges in lower courts, the inferior courts, went off between 2008 and 2022 and imposed, made up, if you will, these interest balancing tests, and then they got spanked in 2022 by NYSERPA versus Bruin. But the Bruin standard was not a new standard. It was simply a reiteration and to some degree a clarification of the standard of text, history, and tradition with no interest balancing test that was initially set forth in the Heller case. So here you have Judge Kendall gets it wrong yet again. Then the next thing is Judge Kendall doesn't understand what kind of case she's sitting in. She is sitting and presiding on a case that is an arms possession ban case, right? It's effectively, and she acknowledges this. We're talking about the sale of these things. Obviously, you got to be able to buy these things. But basically what we're talking about here is an arms ban case where the city and then subsequently the state is effectively banning the possession and or the sale of arms, right? It's a ban case, whether it be the magazines are being banned or the so-called assault weapons, which are semi-automatic rifles, are being banned. And yet here she is talking on page 13 about a variety of regulations. This is not a case about regulations. This is an actual arms ban case. And can you think of a Supreme Court case that actually set forth the standard for what happens if you're a judge dealing with a ban on an arm? Oh yeah, that's right. That would be the Heller case. And what exactly is that standard? Well, you all know it. If an arm is in common use, it is protected. Period, full stop. Why is that? It's because the Supreme Court has said that the only time an arm can possibly be banned is it has to be both dangerous, meaning unusually dangerous, and, that would be and, conjunctive, both dangerous and unusual. And if something is in common use, it cannot by definition be unusual. So what does Judge Kendall do there? She conveniently skips over all of that analysis and instead starts talking about how, guess what? Semi-automatic rifles labeled assault weapons are unduly or unusually dangerous, but ignores the other half of the equation. And how does she play that little game? I'll tell you how she plays that game, believe it or not. She actually, on page 19, misquote. She quotes accurately William Blackstone in one of his writings where he talks about you can't go out in public with dangerous or unusual weapons, but that's kind of a different context. But the U.S. Supreme Court has said when it comes to the American Second Amendment, remember Blackstone was English, talking about English law. We did borrow a lot of concepts from England, but we did not wholesale adopt it. So here the Supreme Court says that the only way you can even conceivably ban a firearm is it has to be unusually dangerous and unusual. That means if a firearm, which semi-automatic rifles and semi-automatic handguns are obviously in common use, right? We know they're in common use because Brett Kavanaugh, in a case of Heller 2, points out that semi-automatic rifles are obviously in common use in the same way the semi-automatic pistols were in common use in the Heller case. Now, does Judge Kendall mention, she actually talks about the Heller 2 case. She even quotes Brett Kavanaugh in the Heller 2 decision in his dissent to some degree. But guess what? She conveniently ignores what I just said, that Brett Kavanaugh, in dealing with the semi-automatic rifle case in Heller 2, actually said that a ban on those kinds of weapons is unconstitutional. And yet, for some reason, Judge Kendall felt it was not appropriate to mention that obvious fact. Now, just to prove the point that she gets the standard wrong, if you look at footnote number 9 on page 18, this is what she thinks the standard is for when a gun ban is allowed in American law. Totally wrong. This is what she writes, quote, weapons associated with criminality may also be unprotected, but given the strength of the historical evidence regarding particularly dangerous weapons, there is no need to consider this alternative ground. That's my response. Because let's go to her historical record of when you can ban guns in America. Now remember, The year of our Lord 1791 was when the Second Amendment was adopted. The founding era runs approximately from 1760, 1770 to 1826 or so. That's approximately the founding era. So anything outside the founding era that deals with gun bans, well, first of all, they don't really exist and it's not really relevant anymore. But anything outside that was completely irrelevant. But let's just begin from the premise that Heller already taught us what the text of the Second Amendment means as applied to gun bans and the historical analogs, which is, the in common use test. If a firearm is in common use, it cannot be banned, period, full stop. Nowhere in this decision does she talk about that magazines are in common use. Nowhere in this decision does Judge Kendall talk about how semi-automatic rifles are in common use. All she wants to do is talk about dangerousness. Dangerousness. That is not the standard. Everyone knows that. So then she goes on and she tries to justify it with history. At the end of the day, this is just interest balancing test. But here's the history she's come up with. None of this history is irrelevant. None of this is relevant because the only question is in common use. That's the only question when you're dealing with a gun or an arm or a magazine or an ammunition ban case. If you're trying to ban a type of arm, it's in common use, period, full stop. That's the only test that matters for our purposes right here and right now. But she conveniently ignores that. So she tries to justify what she's doing by talking about historical regulations on certain types of firearms and other weapons. This is the closest thing she gets. I would say this is the closest thing she gets, and it's absurdly not applicable. She points out that starting in approximately 1837, 1838, early 19th century, after the founding fathers have died. Remember, the founding fathers have to be alive to help give us original public meaning of what the Second Amendment was intended to mean, because once they die, you don't have any original public meaning of what you understand the people that enacted the Second Amendment. So she starts off with certain bans in certain states of Bowie knives, all of which are too late, meaning starting in 1836 and it goes beyond that up to the Civil War. All of that is way too late. It's after the founding era. Then she goes on, believe it or not, and starts talking about blunt weapons. So she goes from Bowie knives, which again, laws enacted way after the founding, so they're not relevant because they're too late, and they're knives. So, and also, it looks like they're in outlier jurisdictions, but let's set that issue aside. And then let's go on. She starts talking about bans of clubs and other sort of blunt objects. And then she talks about things like 1862, the city of Leavenworth banned billy clubs. Indiana banned certain kinds of clubs in 1905. Now, here's the thing. She's selecting some examples of bans of billy clubs and other blunt instruments. But again, they're all too late. But none of this can possibly be true, because here's why we know this, because she's not learning her history. In the year 1770, we had the Boston Massacre, which was a mass shooting, by the way, but set that issue aside. In 1770, you had Bostonians with clubs walking through the city of Boston. And then you had the Boston Massacre, where the British officers shot 11 Bostonians, killing 5 in a mass shooting in 1770. But here's the thing. During the trial of the British officers after the Boston Massacre, they were represented by none other than founding father John Adams. That's right, President John Adams, founding father. John Adams said in open court that Bostonians and Americans had every right to bear arms in public in self-defense, which would, at the time, was the clubs that she claims that the founding era was banning. Clearly not true, because even John Adams said that you could bear arms in the form of clubs in Boston at the time of our founding. She ignores all of that history to talk about and cherry pick a handful of these regulations on clubs as if somehow this speaks to firearms and the right to keep and bear arms. But that's what she does. Then she goes on, believe it or not, and this is absurd. She starts talking about, again, late 19th and 20th century laws. She starts talking about trap guns. Trap guns. Now, you know what a trap gun is? Trap guns are guns. There's two types of trap guns. I'm going to be very general here. There's trap guns that you use to, you set up a trap for someone that breaks into your home and you shoot them. Well, and also you can also have them in the context of gaming laws where you set up a trap gun. So if a deer walks by or an animal walks by, the gun goes off and you shoot the animal. Okay, These trap guns were banned in places, not because it was gun control, but because they didn't want loaded guns sitting out and about where somebody could by mistake walk by and get killed by mistake. So trap guns has nothing to do with you having a gun in your possession for self-defense or for hunting or for any other purposes. So she tries to rely on some 18th, 19th, and 20th century trap gun rules to somehow speak to this, somehow speaks to the issue of assault weapons, so-called assault weapons, which of course none of this has anything to do. These are really hunting regulations in the context she cited. And if you look at the years on page 23 that these laws came out of, they're all way too late. There's laws involving trap guns from 1887, 1889, 1852, 1878, 1869. These are all way after the founding of America and have nothing to do with the meaning and the definitions of the Second Amendment. And yet this is what she relies on. Then on page 24, she starts talking about 20th century laws. The Supreme Court has repeatedly said that 20th century laws are utterly irrelevant to the meaning of the Second Amendment. In fact, keep in mind that 1911 was the year the Sullivan Law, which was the sort of first ban on carriage without a license in the state of New York, was literally just struck down by Naperville versus Bruin. That was in 1911. It was considered not long-standing tradition because it didn't go back to the founding. And here you have Judge Kendall relying on laws that were enacted in 1927, 1933, 1933, 1932, and so on and so on. These 20th century laws restricting certain machine guns and some other related firearms in a handful of states, again, is not long-standing, and it's also, these are outliers. Again, none of this has anything to do with the founding era and interpreting the meaning of the Second Amendment. So what does she do? After all this, this is what her conclusion is as to the meaning of the Second Amendment as applied to this case. This is her quote, "The history of firearm regulation." It's not a regulation. Hello? This is not a regulation of firearms. This is a ban on so-called so-called assault weapons, a ban on semi-automatic rifles, a ban on magazines. And yet here you are in her concluding paragraph says, quote, "The history of firearm regulation then establishes that governments enjoy the ability to regulate highly dangerous arms and related dangerous accessories. The final question is whether assault weapons and large capacity magazines," she's using propaganda terms in her opinion as a judge, "the final question is whether assault weapons and large capacity magazines fall under this category. They do." Absurd. Absolutely absurd. This is a trash opinion in my opinion. She gets the standard wrong. She doesn't apply in common use. She talks about English law in the form of William Blackstone, ignoring all the American precedents that came after that says it's not dangerous or unusual. It's dangerous and unusual. And basically, the rest of this is nothing but a propaganda document written, as far I can tell, is right out of an anti-gun propaganda piece talking about the so-called dangers of semi-automatic weapons, never mentioning, of course, in any way, shape, or form, the benefits of firearms, the lives saved with firearms, or any of these things, and nor should she talk about that. Do you know why? Because it's not appropriate anymore. The Supreme Court says that the law of the land, if you're trying to ban an arm, is in common use. That's the test. She does not apply this test. So what's going to happen with Judge Kendall's opinion? I'm guessing they're going to take an immediate appeal to the Seventh Circuit Court of Appeals. And those judges in the Seventh Circuit, I suspect, will apply the right test and I think, get it right. But for now, this opinion is out there. She denied the motion for a preliminary injunction on the grounds that it did not implicate the Second Amendment to ban the sale of magazines or these rifles or the possession of them or any of the above. And I think this is clearly wrong. And I think it will get fixed in due course. But yeah, this opinion, not impressive at all. And if you want to learn about how not to write an opinion involving the Second Amendment, I would recommend strongly you read the opinion of Judge Virginia Kendall in the Northern District of Illinois in Bevis versus the city of Naperville, Illinois. Okay, folks, hope you learned a little bit something here about this breaking news. If you haven't subscribed, make sure you do so, and we'll talk to you again soon here at the Four Boxes Diner.
Orders up. Table 2A.